to transfer venue should be heard as promptly as possible. The court has set both of the defendants' motions to transfer venue in this case for hearing. The incident that we're here for, this lawsuit involves a tractor trailer collision between two tractor trailers.
I'm sorry, go ahead. I'm sorry.
A little bit of background for you. Unfortunately, Judge, both individuals, the drivers that were involved in the accident, died as a result of the collision. The collision occurred, Your Honor, on July 24th of 2021 in Ector County. The vehicles were traveling in opposite directions. There's not been a whole lot of discovery, obviously, because suit has just been filed and there are motions to transfer venue as to what happened. But both of the vehicles came together, causing a severe collision, resulting in the death of one driver, Mr. Alonzo, and another driver involved in the Mr. Gilbert Ureste. The lawsuit has been brought by Mr. Pena on behalf of the Ureste family. First off, it was actually, brought by Mr. Greenberg on behalf of the Alonzo family. He filed the lawsuit in El Paso, Texas, and named the motor carrier for the other driver, Mr. Ureste, as a defendant. The other driver's motor carrier is Fifth Floor Freight, who is represented by Mr. Snyder. Mr. Snyder has filed a motion to transfer venue as well. As I said, the incident resulted in deaths to both drivers. Mr. Pena represents the family of the other driver, Mr. Ureste, and has intervened in the case on behalf of the wife of Mr. Ureste, Mrs. Guzman. A third plaintiff in the case is the intervener, who are represented by Mr. Forbes, and that involves Mrs. Erickson and another individual who I believe are the children of Mr. Ureste. They have intervened in the case as well. There appears to be a dispute, at least from what I can tell, as to who would be the proper representative of the estate of Mr. Ureste in the case. I represent Detmar Logistics, who was the motor carrier for Mr. Alonzo, as a defendant in the case, and Mr. Snyder, as I said, represents Fifth Floor in the case, as both of the decedents involved in the accident, their families have brought claims against the motor carriers of the respective parties. Your Honor, this is a motion to transfer venue. We filed on behalf of the defendant Detmar our original answer subject to a motion to transfer venue, alleging that venue is improper in El Paso. That was timely filed. Mr. Snyder has filed a similar motion to transfer venue subject to his answer, which was timely filed on behalf of Fifth Floor Freight. Your Honor, the venue in this case, we believe does not reside in El Paso, where this suit has been filed. The accident occurred in Ector County, which is in Odessa. The pleadings that are on file with the court all are undisputed that the accident occurred in Ector County. And those are pleadings from basically all of the plaintiffs that are in the case. My client is Detmar. Their principal place of business is in Bexar County. They are not located in El Paso County. The evidence that is on file through way of pleadings by the plaintiffs clearly establish my client's principal place of business being in Bexar County. Mr. Snyder, as the co-defendant, fifth floor, all of the pleadings, and it is undisputed as well, established that his client's principal place of business as a motor carrier is Midland County, Texas. So the issue before the court is whether or not venue lies in El Paso. Mr. Pena, who represents the Ureste family, and contacted my office after we filed our motion to transfer venue and the hearing was set, and requested an extension to file a response to our motion within the 30 days. The rules basically say you have to have your motion response on file within 30 days. I agreed, Your Honor, to Mr. Pena's request to allow him to file a response on behalf of the Ureste family within the 30 days. Mr. Pena likewise agreed to allow me to file a reply to his response before the hearing, and allowed me to do so up until yesterday, which I have filed. So, Your Honor, we've got a reply to the motion to transfer venue, at least against my client, that has been filed by Mr. Pena. Mr. Greenberg has also filed a response and a reply, which I filed yesterday, which I have presented to the court reporter and also the clerk for your review and consideration after the hearing, as well, pursuant to the instructions of the court bailiff. All of those documents will constitute, for lack of a better term, the evidence for the court to consider with respect to the motion to transfer venue. Your Honor, venue on Texas law is based upon the Texas Civil Practice and Remedies Code, chapter 15. There are various provisions with respect to mandatory and permissive venue contained in chapter 15, Judge. Chapter 15.002 is the general venue statute, which would apply to these types of cases, Your Honor. Chapter 15.002 states that venue is proper in the county in which the substantial part of the events or omissions giving rise to the claim occurred. It's undisputed, Your Honor, that's Ector County. It also allows for the county of the defendant's residence at the time the cause of action occurred. Third, it also allows for the county in which the defendant's principal place of business is. In this case, the only parties that are before the court properly as defendants in this case are my client, Detmar, as a defendant whose principal office is in Bexar County, and Mr. Snyder's client, fifth floor, whose principal office is in Midland County. Pursuant to 15.002, the only places where venue is proper is not El Paso County, but rather either Ector County, Bexar, or Midland. However, Your Honor, there is another provision in the Texas Civil Practice and Remedies Code that deals with potential venue when estates are involved in the cases. That venue statute is 15.031. That venue statute allows for venue to be permissible in the county where the cause of action and substantial events, acts, or omissions occurred, which is Ector County and not El Paso. So our position, Judge, is at this time, venue should be transferred either to the principal place of business or the defendants, or where the cause of action occurred. There are two statutes, 15.002A and 15.031, which seem to indicate that venue would arise where the accident occurred, which is Ector County, which when you look at all of those things, put them all together, and you have all of these parties in different counties, well, why don't we do exactly what happened when I played football in high school? When we were lucky enough to get to the playoffs, what we did was we could either flip a coin and figure out we're going to play in San Antonio, Texas, or we're going to play in El Paso, or we can agree on a neutral site. Austin, let the kids play there. In this case, when you put all of these competing interests together, which the court probably even shouldn't do, but if it were to do that, where's the neutral place where the accident occurred? In Ector County. Now, the big issue, I believe, in this case is making sure that we get venue right. There are a lot of parties in this case, Judge, and it's a little bit complicated, probably more complicated than an Aggie from Texas A&M, which I am a graduate of, can probably figure out. But I have done some of the research, and I have provided our motion to transfer venue, our reply, and I believe the plaintiffs have provided their response with briefing in it for the court's consideration. One of the big issues in the case, Judge, is the fact that one of the plaintiffs, the Alonzo plaintiffs, have brought a cause of action against the estate of Mr. Uresti. Now, Judge, that cause of action has been brought as, quote, the estate of Mr. Uresti. The problem with that, Judge, is the estate under Texas law is not a legal entity, and it cannot be sued. The case law, which is in all of the responses and the replies, are clearly state that a suit must be brought against the representative of the estate. And the estate itself is not a legal entity. The court does not have personal jurisdiction over the estate, and it is not a valid party. And that is the current position of the alignment of the parties as we sit here today in a motion to transfer venue. And it's important, Judge, because one of the most important cases that Mr. Greenberg has cited in his response is a case called Watson versus City of Odessa. And he cites to that case for the position that there's venue is proper if the case is maintainable in a county. The problem is that case says directly on point that the court has to determine venue based upon the live pleadings that are before the court at the time of the hearing. We are here at the time of the hearing. The plaintiffs in this case tries to establish venue in El Paso based upon the estate having a representative who has not been sued and is not before the court, having that representative as a resident of El Paso. Well, that, as we sit here today, that estate is not a legal entity. The representative has to be sued. And then the representative, once they file an answer, that could be considered as a factor in 15.002. The problem with all of that is Mr. Forbes, and not Mr. Forbes himself because he's a great attorney, but Mr. Forbes is representing the interveners in this case, Judge. The interveners are the children of the deceased driver, Mr. Uresti, and they have filed a claim in the probate court in El Paso, Texas, probate court number 1. And they alleged that Edith Erickson, the daughter of the deceased, is in fact the representative of the estate of Mr. Uresti. So now we have two parties, two individuals, the wife who resides in El Paso, and we have the daughter who resides in Sacramento, California, Judge. Both of them have filed claims in the El Paso probate court claiming that they are the representative of the deceased. So we've got a case now, Judge, where the plaintiffs are trying to claim that there is venue in El Paso because the wife of the deceased lives there, but they have sued not the wife of the deceased as the representative. They've sued an improper party, which is the estate. And there's questions whether or not she's even the proper representative of the estate, because if she isn't the proper representative of the estate, then it would be a lady by the name of Erickson that is in Sacramento, California, and venue wouldn't lie ever in El Paso. When you put all of that together, you get a situation where under 15.002, the only two parties before the court right now, pursuant to the Watson v. Kelly case, only two parties as defendants do not reside in El Paso. Therefore, Judge, the proper thing is to transfer venue to either the neutral county, Ector, or one of the defendants' counties. Personally, I believe it should be transferred to Ector County. It's real important, Judge, because we do not even get to an issue, although I have pled forum non-convenes. Well, that's what it used to be called back when I first started practicing law like 35 years ago, when my hair was a little bit darker. The question, that's important because we never get to an issue of whether or not it is convenient or not. I had to file my motion to transfer venue and allege my potential causes based upon the fact that I waive them if I don't under the law. However, Your Honor, we don't even get to that point because venue isn't proper in El Paso. Even if we do get to that point, The balance of the interest of all of the parties, as I've just discussed, would be to transfer this case to Ector County. I filed affidavits or an affidavit on behalf of my client saying that none of our witnesses, none of our people reside in El Paso. There's no connection that we have to El Paso. The accident didn't occur in El Paso. So from that aspect, that is the basis of our motion to transfer venue. And I'll let Mr. Snyder talk.
All right.
Good morning, Your Honor, and may it please the court. Interestingly enough, I'm actually sitting outside your courtroom at the El Paso courthouse right now. I did not realize that we would be able to attend this hearing remotely or by Zoom.
I'm so sorry for that, but welcome.
Well, that's quite all right. I don't want to rehash all of the facts that Mr. Page gave to the court about the case. Mr. Greenberg, who represents the Alonso family, they are the plaintiffs who originally filed this lawsuit in your court, Your Honor. And when it was filed, they sued Fifth Floor Freight LLC, my client, and the estate of Gilbert Uresti. Mr. Uresti was our driver. They did not sue the personal representative of Mr. Uresti's estate. So Mr. Page is absolutely correct. At this point in time, the only two legally recognizable defendants who are before the court are Fifth Floor Freight and Detmar Logistics. Detmar's principal place of business is Bexar County. My client's principal place of business is Midland County. The accident happened in Ector County. I think you're probably going to hear from either Mr. Greenberg and or Mr. Pena that, well, you know, we can fix this by suing the personal representative of Mr. Uresti's estate, Ms. Guzman. That's not so, because number one, the determination of venue has to be determined on the basis of the pleadings that are before the court right now. And secondly, as Mr. Page pointed out, there is a contest in the probate court here in El Paso County about who should be appointed to legally represent Mr. Uresti's estate. So as of this moment, there is no legally appointed representative of Mr. Uresti's estate. Therefore, venue has to be determined based upon the provisions of 15002. It's where the accident happened, or it's the principal places of business of either Detmer or Fifth Floor Freight. Respectfully, I think for the sake of judicial economy and convenience, the case should be transferred to Ector County where the accident occurred, because venue would be proper there against my client. It would be proper there against Mr. Page's client. And that would make sense because there is absolutely no reason to have two parallel lawsuits involving the same or similar claims arising out of the same accident pending in different venues, which creates the potential for conflicting results in the event of a trial. So I really do think that the proper thing, in fact, the only thing that the court can and should do is transfer venue of all of these claims to Ector County. And this is particularly important because I know that the court is well aware of this. It's very important that we get venue right, because if we don't get venue right and we go through a trial and the venue where the trial was held was wrong, then that creates the potential for an appeal and a reverse and remand for trial, and all of our time and efforts will have been wasted. So respectfully, Judge, I think the safe thing to do, the proper thing to do, the prudent thing to do is to transfer the case to Ector County. And I'll tender the floor back to the court unless you have any questions for me.
not substantive yet, but I am concerned that you're kind of sitting outside our courtroom here. So if it is better and you have less distractions, I know seems like you've been fine, but we're more than happy to open that door. Bailiff is here. If we have a little foyer that you can sit in if that's more comfortable. Up to you.
I'm doing quite fine out here, Your Honor. Thank you
Okay.
very much.
So now, Mr. Greenberg, you're gonna go first?
Yes, Your Honor.
Go ahead.
Yes, I represent the Alonzo family who filed their lawsuit in El Paso County because Mr. Resty was from El Paso. His estate is, their proceedings are pending in a probate court in El Paso County. First up, under section 304 of the estate code, to be personal representative of his estate is Claudia Guzman, who's from El Paso County. The intervener, who's his daughter, is second, is not under the estate's code who would be personal representative. She's second in line. And under section 304.003 of the estate code, because she's a non-resident and has not filed the proper paperwork, she's disqualified from being the personal representative. Therefore, the only person who's statutorily able to be the personal representative of the estate of Gilbert Uresti is Claudia Guzman. If the court takes a look at my original petition, I did in the caption list the estate of Gilberto Uresti. In the body of my pleading, I sue the estate through its personal representative, Claudia Guzman. She was served with this lawsuit. Mr. Pena can attest to that as her lawyer in her civil claim and cross claims against my client and my client's employer. So I did sue Claudia Guzman as the personal representative of the estate of Gilberto Uresti. She's the only person who can be personal representative under the estate's code, and she lives in El Paso County. As this court is well aware, plaintiffs get to pick the venue of their choice as long as it's at a proper venue. We have a permissive venue statute. The Alonzo family chose El Paso, where Mr. Uresti was from, where the probate is pending, where Ms. Guzman resides. Mr. Pena will also, I think he would tell the court that when she was served with my lawsuit, that he requested a defense from her husband's employer, who's denied that request, meaning that they will not answer for him through her, because if they do, then they fall victim to this motion to transfer venue hearing and the natural consequences of that being that we're stuck in El Paso. If you look at the motions, Your Honor, their argument is clear. It's simple. They would like to be anywhere but El Paso County. They'd like to be where the crash happened. They'd like to be in one of the principal places of business. And I understand that as a defendant that that's their desire. But plaintiffs have a very long-standing, hundreds of year-old right under Texas law to choose the venue of their choice as long as it's proper. And we've demonstrated that it is proper because defendant resided in El Paso County at the time of the incident. I sued the personal representative of the estate, Claudia Guzman, who's the only person who can be personal representative. And she was served with the lawsuit. Defense was requested, but denied. Venue is proper in El Paso County under section 15.002. And even if Mr. Page says we don't have to get to the convenience argument, I think we do, because I think El Paso is a proper venue. Briefly on the convenience argument, Your Honor, if you look at both Detmar and Fifth Floor's petitions, they provide literally zero evidence that they would be inconvenienced in any way. But I think the true test is some kind of judicial or economic hardship. They've produced no evidence that these companies who do business all across the state of Texas would be somehow economically disadvantaged or suffer a hardship to proceed in El Paso County. I'm going to see if Mr. Pena has anything else to add. I may jump in after him, but we have a very clear argument. Plaintiffs get to choose venue as long as they choose a proper one. We've done that, and the defendants don't get to choose the venue. So as long as this court adds up all of the potential plaintiffs, potential defendants for the Guzman family and the representatives of the estate. They're all in El Paso County. So it's either the son who's in El Paso County, the wife who's in El Paso County, the probate proceedings are in El Paso County, and Mr. Aresti lived in El Paso County at the time of his death. That is more than enough to establish proper venue under 15002 and 15031. And the plaintiffs have done that. We ask this court to deny the motion to transfer venue and continue this case in the venue of plaintiff's choice, El Paso County.
Okay, Mr. Pena.
Yes, Your Honor. Just as a follow-up to what Mr. Greenberg was saying, Exhibit 2 to Ms. Guzman's response, it is the affidavit of service, and it does indicate there to be delivered upon the estate of Gilberto Uresti by serving as personal representative Claudia Guzman. She was served with this lawsuit. Mr. Guzman was, or his employer at the time, was fifth floor, and these claims against Mr. Guzman through her do arise from this wreck, and for those reasons, defense was requested for Ms. Guzman. Obviously, as of today, there's not an appearance on her behalf or the estate's behalf. But she was served and named as the personal representative of the estate. Now, Ms. Guzman's status, or I would say her marriage to Mr. Uresti, is not in dispute. Okay, that's not an issue that is before the probate court. And I'm not personally involved in that case, but her marriage is not in dispute. It's just, competing claims for the administration. However, Ms. Guzman is the wife and is likely to, and has preference, under the law to be the personal representative. That is just, it's pending at this point. We talked about the, so for those reasons, Mr. Uresti, he was a resident of El Paso County. He lived with Ms. Guzman. So venue there is proper in El Paso, and she was sued and served as the personal representative according to Exhibit 2. In regards to the convenience argument, Mr. Page did point out in his motion that, as far as anyone that's in El Paso, it is Ms. Guzman and the beneficiaries. He did point that out. As far as convenience of witnesses or additional parties, there really are none. The crash report lists no eyewitnesses. The trooper who knows where he's from, but there's really no one. Of course, both drivers have passed away, so there's really no other connection to Ector County other than where the wreck happened. And as far as the convenience, it's really the two corporate defendants here that are complaining of the convenience, and really any hardship would result in my client and her claims if this case is removed from El Paso County. So regarding venue, I think I've addressed that in my response. The affidavit of service is clear. I believe that the plaintiff's petition is clear as to how we have proper venue in El Paso County. Thank you.
Yeah, and so just to be clear, Your Honor, Mr. Pena is the only attorney who represents Claudia Guzman, who I've sued as the personal representative of the state. He agrees that venue is proper in El Paso. He agrees that she's been served as the personal representative of the estate. So I think under the plain language and the Texas legislature's intent of section 15002, venue is proper in El Paso County, and defendant's desire to push it somewhere else just cannot overcome that.
So I
Judge.
guess let me ask, and before I think I'm headed both.
Mr. Forbes,
Mr. Page.
Mr. Forbes has it. Do you want to, I think Mr. Forbes is an intervener in the case, Your Honor.
Okay.
Before.
This is the question I'm going to have, and Mr. Forbes, I'm happy to let you go in just a second. I'm trying to understand why both Mr. Page and Mr. Snyder are arguing that the representative of this estate is not properly before the court. That's where I am. So hold on to that thought. Let me let Mr. Forbes chime in. Mr. Forbes, if you'll unmute, please. Mr. Forbes, if you'll unmute. If you're speaking, I don't know, I couldn't tell.
That is a good idea.
There you go.
Good morning, Your Honor. How are you?
Good afternoon now.
Good afternoon. That's right. Okay.
Okay, let's go.
Thank you for the compliment, Mr. Page. We've never met before, but I appreciate it. I would like to just say that section 15.031 of the Civil Practice and Remedies Code says that the suit may be brought in the county in which the estate is administered, or against the executor, administrator, or guardian out of a negligent act. In other words, El Paso County is where the estate of Mr. Oresti is going to be administered, like it or not. And regardless of who the appointed executor or administrator of the estate is going to be, this is where that estate is going to be administered, and that's why this court has jurisdiction. I enjoy practicing law in El Paso. I don't know why anybody else would not want to practice law here.
You didn't pick a good day to make that argument. If you look outside, it got pretty dusty out there. That's not homegrown myself. That's the only knock is that we get a bunch of dirt. All right, go ahead, Mr. Forbes. I'm sorry.
But anyway, I don't know why anybody else would not want to practice here. That's what I was saying. But I think the Civil Practice and Remedies Code obviously gives this court jurisdiction and venue to hear this case.
Okay.
That's it.
All right, Mr. Snyder, go right ahead.
All right, Judge, let me address the question that you asked, and that's why, or Mr. Page and I contesting that the personal representative of Mr. Oresti's estate is not a party before the court. And I'll tell you why. If you look at the Alonso family's original petition, and if you, starting on page 1 and going through page 3, it identifies each of the parties to the lawsuit. All right? When you get to the top of page 3, in the paragraph numbered 8, it says defendant estate of Gilberto Oresti is the estate of deceased individual Gilberto Oresti. That is the presumed party that the Alonso family sued. They did not sue the personal representative. What they attempted to do is they attempted to serve the estate with legal process through its presumed personal representative, Claudia Guzman. Now, that is exactly analogous to someone bringing a lawsuit against a company or a corporation. A company or a corporation can only be served through its registered agent. But the mere fact that legal process has been served on the registered agent does not mean that the registered agent becomes a party defendant to the lawsuit. And that's a very important distinction here, Your Honor. They sued the estate. The estate is not a legal entity. Mr. Oresti could not be sued because he is deceased. And we have set out in our motion, our supplemental motion to transfer venue, the case of Price, the estate of Anderson. It is a 1975 Supreme Court case, which interestingly enough arose in a district court right here in El Paso, Texas in 1975 and went up through the El Paso Court of Appeals. But the Supreme Court said two important things in that case. Number one, when somebody dies, you cease to have the ability to sue them. And if you sue them, for a debt or a claim that you think that you have, you can only do so by suing their personal representative. You cannot do it by simply suing the estate, because the estate is not a legal entity. And that's, I think, what is being missed here. The only parties before the court right now against whom claims have been made are Fifth Floor and Detmar Logistics. Neither of them do business or have principal places of business here in El Paso. And so it is for that reason that I, on behalf of my client, have asked that the case be transferred to Ector County. I understand we asked that it be transferred to Midland County, which is where we do business. But that really doesn't make sense, because then we end up with two parallel lawsuits. Everything needs to be in one lawsuit. And the thing that is common in terms of venue to all parties is the fact that the accident happened in Ector County. And that's where I think the case belongs. And to address Mr. Forbes' point about the Estates Code, the venue provisions in the Texas Civil Practice and Remedies Code trump those in the Estates Code. And so it is the provisions in the Texas Civil Practice and Remedies Code that control. I'll tender my time back to the court.
Yeah.
Your Honor, can I respond?
I just
Hold
wanted
on,
to tell you,
hold on. Whoa,
just
whoa.
wanted to tell you, I was reading from the Civil Practice and Remedies Code. I was not reading from the Estates Code.
Right. I
My
got you.
apologies,
Okay. Thank
May I-
you. Your
May I
page.
respond, Your Honor?
You may.
I don't know how to share. Can I share screen?
I think we can allow you to do that. I
Can-
don't know how to do it,
Can,
but
can somebody do that for me? The
somebody-
host, it
the
says
host
host
is
is,
gonna try and do it. Just
okay.
bear with us.
Judy, on the bottom, do you see the option?
Yeah, it
Yeah,
says host has disabled participant screen
Hold
sharing.
on, gentlemen. Let me talk to the bailiff real quick.
Okay,
Which one should I click on, Sandra, then?
is that
Okay.
Chewy?
So you, yes, so you click the little arrow, the little carrot, and then you click where it says multiple participants can share. You see it?
Okay, I think. Give me a second. Let me transfer back to Sandra.
Okay. Gentlemen, whoever wants to share, it should be enabled now. Double check for me, please.
Yeah, we can.
Okay.
Share away.
Okay, I'm sharing. That's what I learned in the third grade, the second time I took it. Okay, so Your Honor, I would like to add in response to the question of before the court, why we take this position, me and Mr. Snyder. It's very important that Ms. Guzman has not filed an answer yet before the court as defendant. There's no answer that has been filed for as a defendant. This is the case Watson versus Odessa that I'd like to show to the court. It says here, therefore, at the time of the venue hearing, the trial court could only consider the live pleadings and affidavits and attachments as they may be filed with the court. So that is one of the positions why we believe that. Secondly, with respect to who is proper before the court, again, the estate, according to this case, Your Honor, Miller versus Self, which is cited in my response, the estate of a decedent is not a legal entity and may not sue or be sued as such. A suit seeking to establish the liability of an estate should be filed against the personal representative or in certain circumstances, the heirs or beneficiaries. No suit's been filed against Claudia Guzman as the personal representative. According to the live pleadings, they have sued the quote estate, which is not a legal entity and may or may not be sued.
Can I ask you, Mr. Page, on this one? And I'm already telling you all, I'm gonna have to go back and look at a lot of this. But
Yes.
can you tell me in this, well, I don't know if it was the Miller case or the Watson case or both. Well, we're talking about suing the estate. Was there any indication in the petition on the petitions on those cases? Was there ever a mention of a personal representative? For example, was it solely filed in those cases as the estate? There's no indication of there being a personal representative. Is that distinction there, or is it like this case?
Well, in both of those cases, one, Your Honor, I must admit, I don't have the pleadings from those cases.
I just
So
wondered, sometimes they'll say, well, in the original petition, it said this. Sometimes that's in the notes in the opinion. Having not seen the opinions, I didn't know.
yeah,
That's
I could not say that. I know in one of the cases, I believe it's not the Miller, but if I can get the Coates case up, Your Honor. I believe in this case, there was a individual that was involved in the case, and the question became whether they later personally participated in the case, such that when it went on appeal, whether they were a proper party or not.
okay. I just thought I'd ask. You know a lot about it, sounds like. So thought if you knew it was there, you might be able to tell me. Go ahead, keep going.
So that's kind of where we're at, Your Honor. That's in response to the questions that were posed by the court.
And Judge, this is Norm Snyder again. I don't mean to interrupt, but I did not address this. The question was posed, why hasn't anybody responded on behalf of Ms. Guzman, Mr. Uresti's widow?
Mhm.
And the reason is because she has not been sued in her individual capacity or in her capacity as the legal representative of her husband's estate. That's the reason. And if she is someday sued either in her individual capacity or as the legally appointed representative of her husband's estate, it's my expectation that a defense will be provided for her. But until she's before the court as a party defendant, there is no defense to be provided to her.
Okay.
Yeah, Your Honor, and my response is I just simply disagree. I think that they're reading my petition in the way that's most favorable to this specific argument. I think when you look at the entirety of the petition, it's and the case law that was just cited that you can't sue an estate. It's clear that the estate is only being sued through the personal representative, Claudia Guzman. It distinguishes that plaintiffs are not suing her in her individual capacity, but she's being served with a lawsuit on behalf of the estate of her husband for the acts that he committed as the defendant driver in the death of my client. I think that's fairly clear from the pleadings, and it says specifically in my original petition that I am suing Gilberto Oresti through his estate through its personal representative, Claudia Guzman. Her address is listed. She was served with it. She requested a defense believing that she's been served, and that's been provided. So I think if you take a look at the pleading and you take a look at defendant's case law that they just cited saying that you can't sue an estate, you sue the personal representative. I think it's clear that that's what happened in plaintiff's petition, and therefore venue is proper under 15002. Also, the proceeding is the appropriate proceedings are occurring in El Paso County, so under 15031, venue is also proper under that section. So we've got two different sections of the Texas Civil Practice and Remedies Code that provides venue in El Paso County, and therefore it's a proper venue. And then the analysis shifts to whether or not El Paso is inconvenient, and there's no evidence in the defendant's motions or on the record at all that El Paso is an inconvenient place for the defendants to litigate. And so for those reasons, the plaintiffs asked this court to deny the motion to transfer venue and keep the case in El Paso.
Anyone else? Mr. Forbes, you may go ahead.
Yes, I was just reading part of the Miller versus the state of Self case. And at page 556, there's a place where it says a suit seeking to establish liability of an estate should be filed against the personal representative or in certain circumstances, the heirs or beneficiaries. So it does allow the suit to be filed against the heirs or beneficiaries. And the defect in parties is the one to bring the defense is the person that's been served, not necessarily another party in the case. That's at page 556 of that Miller versus the state of Self.
Okay, all right. Any last comments?
Sure, Your Honor. If I could share the screen with respect to, and can you all see that? Can you all see that?
No, we can't.
How's that?
No. Have you been?
There you go.
There it is. There it
You
is.
got it?
Mm-hmm.
Okay. Here's 15.031, Your Honor. And it says right here in 15.031, if the suit is against an executor, administrator, or guardian. We beat this to death, Your Honor. They haven't sued the executor. They haven't sued the administrator. They haven't sued the guardian. They have sued a non-legal entity, the estate. Based on the live pleadings now, section 15.031, the first part doesn't apply because they haven't sued the executor or the administrator. The second part of 0.031, which I have highlighted for the court, applies. Or if the suit is against an executor, guardian, whatever, growing out of the admission of the person whose estate the executor represents, the suit may be brought in the county in which the negligent act or omission against the state represents occurred. It's complicated. It's a complex issue, Judge. At least on my behalf, I've tried to provide the court with as much of the case law and as much of the provisions as I know. As a defendant, I'm very interested in two things in this case. One is that I do get the proper venue, and we get that nailed down. And two, at some point in this case, that all of the proper parties are before the court, because this is a double fatality, and it's going to involve a significant amount of discovery and funds expended to get to a position where we are potentially able to either settle the case or to try the case. Thank you, Your Honor.
Thank you, everyone. Anything else? Look, my
The
thought
only
is.
thing- Yeah,
Go
well,
ahead.
the only thing that I would say is the only person here who represents Claudia Guzman, the personal representative of the estate, is Mr. Pena. And both he and his client believe that they've been served with the lawsuit. And so neither Mr. Page nor Mr. Snyder represent Ms. Guzman. And so plaintiff says that she's been served as the personal representative of the estate. So does her lawyer, and that is apparently her understanding as well. So I think that's a factor in the court's analysis as to whether or not they've been served. The only people who are complaining about the wording of my petition are the defendants in their motion to transfer venue.
Okay.
Your Honor, I'd just like to add as well that Ms. Guzman has also, filed cross claims and counterclaims, and that's how Detmar Logistics has been brought joined in as a co-defendant in this case, and that venue proper against one defendant is proper against all defendants. That's 15.005 of the Civil Practice Remedies Code.
Okay, anything else on that? That was a.
But Judge, my only response to that is that although Ms. Guzman has appeared in her individual capacity in this suit, she has appeared in it as a party who is bringing a claim, not as a party who is being sued or is a defendant. And the fact that she's brought a claim here, that has nothing to do with the court's decision as far as venue. We do not deny that Ms. Guzman was served with legal process with the Alonso lawsuit. What we do dispute is that she herself was sued because it was the estate that was sued. She just happened to be the person that got served. That's all.
All right. Well, look, as I mentioned earlier, I have to look a little more closely at a lot of what you all brought forth today, but I think I understand what you're arguing. So my thought normally would be to probably put us just 1 week out to give me the time to do that. I do know, though, looking at 1 week out, that puts me I'm fingers crossed in trial the following day, and we will be doing a few things. So I'd like to do it 2 weeks is what I'm telling you. I'm going to put a status for March 2nd at 11 a.m. They are all virtual, Mr. Snyder. I hope you don't have to trek out again.
Yes, Your Honor. I fully
I'm sorry
understand
about
that now.
Okay, sorry about that, but we're gonna do 2 weeks. Yeah, we'll do 2 weeks. We'll do 2 weeks. I think that should be good enough. We won't be too crazy.
I bet Mr. Forbes will buy you lunch, Norman. I threw you under the bus.
No, that's quite all right. What the court and everybody doesn't know is that for 15 plus years, I played in a golf tournament held at Coronado Country Club in August, the Canyon Capers. And I have enjoyed my many visits to the El Paso area. I have no problem litigating here. I've litigated cases here before. It's just that I don't think it's proper in this situation. So
I hear
anyway,
you. Well, don't get blown away.
what I was going to suggest, Your Honor, is as you look through the pleadings that the parties have filed, if you have any questions or if there's anything that you would like any one of us or all of us to address more specifically, let us know and we'll be happy to oblige you.
Well, just on the front end, know this, if I'm not there yet, that's what we will be discussing on that March 3rd date. Okay,
All right, thank
Yes,
you very
ma'am.
much.
Thank you, Your Honor.
gentlemen,
Thank you, Your Honor.
thank you very much. Stay
Thank you.
well. Appreciate your time.
Bye.
All right, True, that's it, right?
Yes, Judge, that takes care of the morning docket.
Okay. I thought, okay, let's get off of YouTube. How about that?
Okay.
Sandra, can you stop the